Welcome back to the Deep Dive. Today we have a mission. We're going to dissect a landmark 1921 New York Court of Appeals case that it fundamentally changed how we think about contracts, construction, and frankly, the whole concept of fairness.
It really does.
This case draws a hard line in the sand between strict, letter of the law compliance and just plain common sense.
It absolutely does. And it introduces this tension that, well, every law student studies, and I think every homeowner eventually feels. It's that battle between getting exactly what you paid for and being reasonable.
Absolutely. So I want to set the stage here because the context is just everything. Imagine it's 1914. We're in New York. The Gilded Age is kind of winding down, but the money is still big.
Oh, very big.
You have a wealthy man, Mr. Kent, who hires a builder to construct a country mansion. And we're not talking about a cabin in the woods. This is a massive, sprawling estate. The contract price back then was upwards of $77,000.
Which, just to give you some perspective, is easily over $2.5 million in today's money. This was a significant project.
Exactly. So the builder, Jacob and Youngs, works on this mansion for months. They finish the house. Mr. Kent moves in. He's living there. But a year later, the final bill comes due. There's an unpaid balance of about $3,400 remaining. And Mr. Kent refuses to pay it.
Right. And $3,400 in 1914 is roughly $100,000 today. So this isn't pocket change. He's withholding a pretty significant chunk of money.
And the reason why is it's the stuff of legends. It wasn't because the roof leaked. It wasn't because the foundation cracked. It was because deep inside the walls, the plumbing pipes had the wrong brand name stamped on them.
That is the exact set of facts that gave us the doctrine we're analyzing today, the infamous reading pipe case.
It sounds incredibly petty on the surface, doesn't it? Withholding $100,000 in modern value because of a stamp on a pipe. Yeah.
But, legally, if we look at this strictly, didn't Mr. Kent have a point? Well, that is the million-dollar question, or I guess the $3,400 question. We need to follow a specific analytical path to really understand the mechanics here. We're going to cover two critical legal doctrines.
Okay.
First, the doctrine of substantial performance. This answers the question: when is a contract finished enough to demand payment, even if there are, flaws?
Okay. And a second.
And second, the measure of damages. So if the builder did mess up, are they owed the cost to fix the mistake, or is it just the difference in value?
And we're looking at this through the eyes of the legendary Justice Benjamin Cardozo.
We are. His opinion in this case creates this vital distinction between what he calls dependent conditions, which block payment entirely if not met, and independent promises, which allow the builder to get paid minus some damages. It's a masterclass in legal reasoning.
Okay, let's unpack this. Before we get to the specific case analysis, I have a conceptual question. I want to play devil's advocate for a second. Under the common law, if I contract for specific work like paint my wall blue, don't I have the right to get exactly what I asked for before I hand over my money? If you paint it red, why on earth should I pay you anything?
That is the intuitive position, and historically, courts were very, very strict about that. It's called the perfect tender rule for goods and strict compliance for services. But here is the general rule of substantial performance that Cardozo really champions.
Okay.
While courts generally require full performance, they realize that strict perfection is often impossible or, frankly, oppressive, especially in complex construction projects. So the rule is this: if an omission or a defect is both trivial and innocent, it will not result in forfeiture.
Forfeiture meaning the builder gets $0 and just walks away with nothing.
Exactly. Forfeiture is the law's enemy here. So instead of forfeiture, the court treats the requirement as an independent promise. This means the builder can recover the contract price, but, and this is key, minus an allowance for the resulting damage to the owner.
So you get paid, but you have to pay for your mistake.
Precisely. It prevents the owner from getting a free house just because of a small error, while still acknowledging that there was, in fact, a breach.
All right, let's test this rule against our case today. Jacob and Youngs, Inc. v. Kent, the famous reading pipe case. Let's analyze Jacob and Youngs. First, what are the legally dispositive facts?
So the plaintiff, Jacob and Youngs, built a country residence for the defendant, Mr. Kent. As we said, the total cost was over $77,000, and the unpaid balance was roughly $3,400. The contract specifications explicitly required that all wrought iron pipe be well galvanized, lap-welded pipe of the grade known as standard pipe of Reading manufacture.
Reading manufacturer. So that's the specific brand. It had come from the Reading factory.
Correct. So in March of 1915, after the defendant had already been living there for a while, he discovered that some of the pipe wasn't Reading brand. It was made by other factories, like Cohoes. The architects, sticking to the strict text of the contract, ordered the plaintiff to redo all the work.
And that's where the physical reality of construction just crashes right into legal theory. Because where were these pipes?
They were already encased in the walls. In some places, they were buried in the foundation. So to obey that order and replace the pipe with the Reading brand meant demolishing substantial parts of the completed structure.
Wow.
We're talking about tearing down expensive masonry, ripping out walls, and essentially destroying the house just to reach the pipes. The plaintiff refused to tear down the house. The defendant, Mr. Kent, refused to make that final payment.
So we have a standoff, a completed mansion, the wrong brand of pipe inside the walls, and a refusal to pay. And what was the core legal issue here?
The issue is this. Does the installation of the wrong brand of pipe where the quality is identical constitute a breach of a condition precedent that forfeits the builder's right to payment? Or is it a trivial breach that allows for substantial performance and recovery of the balance?
Okay, so what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
So, Justice Cardozo applied the doctrine of substantial performance. The rule is that a builder may recover the contract price if the defect is both unintentional and trivial. We can break this down into 3 testable elements or factors that the court weighs.
Okay, what's the first one?
First, the nature of the default. In other words, was it willful or was it innocent? Second, the nature of the deviation. Is the defect dominant and pervasive, or is it just trivial? And third, the measure of allowance, or what you might call proportionality. Is the cost of literal fulfillment grossly out of proportion to the good to be obtained?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the nature of the default?
Okay, so the sub-issue here is willfulness. Did the builder intentionally cheat the owner? And the sub-rule is that the willful transgressor has to accept the penalty of his transgression. He gets no mercy. However, the unintentional transgressor may hope for mercy.
And what did the facts show?
Looking at the facts, the court found that the omission of the Reading brand was neither fraudulent nor willful. It was the result of the oversight and inattention of the plaintiff's subcontractor. It was a simple mistake, not some scheme to save money. So the conclusion on this element is that it was met. The default was innocent, not willful.
Understood. So if he had done it on purpose, if he bought cheap pipe to pocket the difference, he loses right there.
Yeah.
But it was an accident. Now, what about the second element, the nature of the deviation?
Here, the sub-issue is triviality. Is the defect so dominant that it really frustrates the purpose of the contract? And the court's analysis focused heavily on the quality of the pipe. The evidence showed that Reading pipe was distinguished from other brands like Cohoes only by the name stamped on it.
Just the stamp.
Just the stamp. The other brands were the same in quality, appearance, market value, and cost. It was physically the same product, just made in a different factory. Cardozo reasoned that nowhere will a change be tolerated if it's dominant or pervasive, but here the defect was insignificant in its relation to the overall project. So the conclusion on the second element is that it was met. The deviation was trivial, not substantial.
It was literally just a stamp. That's a crucial detail. Now let's look at the third element, the proportionality of the remedy. This seems to be where the encased in the walls fact really matters most.
Exactly. This is the analysis of the cruelty of enforced adherence. The sub-issue is whether enforcing the strict letter of the contract is oppressive relative to the benefit. Cardozo weighed the purpose to be served against the oppression of forfeiture.
And the facts.
The facts are crucial here. The pipes were already built into the structure. To replace them meant demolishing the house. The cost of replacement was huge, just a great expense. On the other hand, the difference in value between a house with Reading pipe and a house with Cohoes pipe was nominal or nothing.
So no real difference in value.
Right. And Cardozo stated that the law is slow to impute a purpose where the significance of the default is so grievously out of proportion to the oppression of the forfeiture. So the conclusion here is that the third element is met. Enforcing the strict condition would be oppressive and grossly disproportionate.
And after analyzing all these elements, innocence, triviality, and proportionality, what was the court's final conclusion?
The court held for the plaintiff, the builder. They concluded that the promise to install Reading pipe was an independent or collateral promise, not a dependent condition. Therefore, the builder had substantially performed the contract. Jacob and Young's was entitled to the unpaid balance minus the difference in value caused by the breach.
And the difference in value was 0.
The difference in value was 0, so they essentially got the full amount.
That is a massive win for the builder.
Yeah.
But I have to pause here. I need to push back. I'm thinking about our listener who might be a stickler for details. I want to talk about the dissent. Justice McLaughlin was absolutely furious about this decision, wasn't he?
Oh, he was. And his argument is very compelling if you believe in the sanctity of contracts.
Because if I'm Mr. Kent, I'm sitting there thinking, I didn't ask for pipe that is just as good. I asked for Reading pipe. Why should the court let the builder off the hook just because the builder made a mistake?
That is exactly McLaughlin's point. He argues that the defendant had a right to contract for what he wanted. He says it doesn't matter if it was a mere whim. If he wanted Reading pipe, he was entitled to Reading pipe. By saying it's just as good, the court is essentially rewriting the contract between two private parties.
Right. McLaughlin's basically saying, it's not up to the judge to decide what is important to me. If I want a house built entirely out of green cheese and I pay for it, you better build me a green cheese house. You can't just build it out of cheddar and say, well, the nutritional value is the same.
Exactly. McLaughlin argues that since the builder failed to perform the condition, he shouldn't get paid, period. He believed the majority opinion was dangerous because it introduces uncertainty. Suddenly, what the contract says isn't the final word. What the judge thinks is fair becomes the final word.
But Cardozo counters this with the idea of economic waste, right?
Yeah.
This seems to be the trump card for the majority.
Yes. This is the concept that the law abhors waste. Tearing down a perfectly good $77,000 mansion just to change a stamp on a pipe is an act of economic destruction. It destroys value for no good reason. Cardozo is looking at the aggregate wealth of society here. He's saying, we aren't going to sanction the disruption of a building for a mere technicality.
It's the clash between freedom of contract and common sense fairness. And to really lock this in, I want to talk about damages, because Cardozo gives us a specific way to calculate this that is, well, it's counterintuitive. He uses a hypothetical about a granite foundation to explain why Mr. Kent doesn't get the money to tear down the house.
Yes, this is the visceral hypothetical that really cements the rule on damages. It comes directly from the source material, and it clarifies the difference in value rule.
So imagine specifications call for a foundation built of granite quarried in Vermont. That is the contract.
Specifically, Vermont.
Upon completion, the owner learns that through the blunder of a subcontractor, the foundation was built of granite from New Hampshire.
Right. And critically, for the sake of the hypothetical, the quality is identical. It's the same geological strength. But just like the pipe, to fix it, you would have to tear down the entire building right down to the foundation.
So if I'm the owner and I sue, what are my damages? My gut instinct says, you promised Vermont granite, I didn't get it. You owe me the cost to tear it all down and put in the right stone.
And that is where you would be wrong under this ruling. Cardozo argues that the cost of completion, the cost to tear it down, is grossly disproportionate to the benefit you would get. So instead of the cost of repair, the owner is entitled only to the difference in value.
The difference in market value.
Correct. You look at the value of the house with Vermont granite. You look at the value of the house with New Hampshire granite. And you subtract the two.
And if the value of the house is the same with New Hampshire granite as with Vermont granite,
then the damages are zero. You get nominal damages or nothing. Cardozo says the measure of the allowance must be shaped to the same end as the rule itself, which is justice. He's preventing the owner from using the law to extort the builder. Because if the court awarded the cost to tear down the house, Mr. Kent wouldn't actually tear down the house, would he? He would just take the cash and keep the house as is.
That's the key. It prevents a windfall. Mr. Kent would just pocket the money and live with the Cajo's pipe.
Precisely. And that is what Cardozo refused to allow.
Okay, we have covered the case, the elements, the dissent, and the damages. Now, I want to help our listener, the learner. If they're looking at a fact pattern, maybe for an exam or a real-life business dispute, how do they know if substantial performance applies? Can you synthesize these rules into a diagnostic checklist?
Absolutely. We can boil this entire complex case down into a substantial performance diagnostic checklist. If you encounter a botched contract scenario, just run through these 4 steps to see where you stand.
Right.
Step 1 is to check for willfulness. Ask yourself, was the breach intentional? Did the builder try to pull a fast one? If the answer is yes, stop there. The builder is a willful transgressor. Strict enforcement applies. No payment. If the answer is NO, it was innocent or an oversight, you can proceed to step 2.
Okay, step 2.
Step 2 is to assess the defect. Ask, is the defect structural, dominant, or pervasive? Does it frustrate the main purpose of the contract, like building the house on the wrong lot or forgetting the roof? If yes, it's a material breach, no substantial performance. If no, it's trivial, technical, or the quality is the same, you proceed to step 3.
And step 3 is the big one.
Step 3 is to weigh the remedy. This is the economic waste test. You compare the cost of completion versus the difference in value. Ask, is the cost to fix the mistake grossly disproportionate to the benefit attained, like tearing down walls for a stamp on a pipe? If the cost to fix is huge and the benefit is tiny, the remedy is limited to the difference in value.
And finally,
step 4 is simply the result. If you have an innocent breach that is trivial and the cure is disproportionate, the contract is substantially performed, the builder gets paid the full contract price minus the difference in value.
that is incredibly clear. So innocence, triviality, and economic waste. If you hit those 3, you are in Jacob and Young's territory. It really is a safety valve for contract law.
That is the perfect way to describe it. It's a safety valve against oppression.
So what does this all mean for us? What's the big takeaway here beyond, plumbing?
I think the key lesson is that the law cares more about fairness and preventing oppression than it does about symmetry and logic, or strict adherence to every single letter of a contract. Cardozo famously wrote that those who care more about symmetry than justice will be troubled by this rule. But he believed the law has to adapt to human fallibility. We're humans. We make mistakes. If every small mistake resulted in total ruin, no one would ever build anything.
It really highlights that tension in the law that still exists today. We want people to keep their promises, that's the McLaughlin view, but we don't want the law to be used as a weapon.
Exactly. If the owner could withhold the entire $3,400 over a stamp on a pipe, that would be grossly unfair. It would be using the law to get something for nothing, and Cardozo just wasn't having it.
And here is where it gets really interesting for you, the listener.
No.
I want to leave you with a provocative thought to mull over. Justice Cardozo saved the builder from a harsh penalty because the pipes were scientifically identical. But think about your own life in the modern consumer world.
It changes things when it's personal.
Exactly. If you ordered a specific brand of product, say a specific high-end luxury handbag or maybe a very specific graphics card for your computer, and the seller sent you a generic one that was scientifically identical and performed the exact same way, would you feel cheated? Or would you agree with Justice Cardozo that it's just as good?
It's a question of whether we value the thing, the utility, or the promise itself.
Deep thoughts for Plumbing Case. Thanks for diving deep with us.
A pleasure.